Dear friends, I'm just making this video more of connecting the theory, the jurisprudence, various schools of jurisprudence to the life situations for us to understand. And I have chosen Honorable Justice Abhay, who is the Honorable Justice of Supreme Court of India and is going to retire in May. Now, what is this jurisprudence? I know all of you know it, but then jurisprudence is the science of law. And that first, the word jurisprudence is coined by Bentham. And then his disciples taken that forward. And that was the utilitarian theory, wherein the purpose and science of law based on the doctrine of positivism is the entire law is based on doing maximum good to maximum number of people. That is the basis. Then I'm not going to the theoretical aspect is whether I'm able to connect the Lordship's judgments, conduct, very many things to this theory. And we would like to introduce that sociological school of jurisprudence. Is this, I can first, before I go into this and try to say that his adjudication comes under this branch, this school of jurisprudence. First of all, why did I observe their lordships? Actually, 2 years back, 3 years back, I went to Supreme Court. Then in another case. Then when I was sitting there, the large chambers, everybody were talking, gossiping and all. And then one senior counsel was telling that Abhay Oak is 24 karat gold. Then, in one other case, one young boy is telling, oh, if the case comes to him, thank stars, thank your God. All round. There's nobody will say, oh, very good. He will. So that extent, see, my close friend Ram Subramaniam also was the Supreme Court judge at that time. He's also known as a great jurisprudence. But then started getting interest to analyze. It's a blend of law and how the law can be made practicable, bold. See, everybody may know law. Every judge knows thing. But then when you want to deliver the judgment according to the Constitution, many of them may not be inclined seeing the consequences. But this is a very beautiful judgment. So I've analyzed one by one. But this is an introductory part of my video. About 5 videos I've done. And after editing, searching, and all take a little time. So ultimately, I chose the lordships. One, based on the unanimous views of the people in the lawyers, these juniors, seniors, advanced lawyers, everybody have such great respect. So actually, we all know that judiciary is the duty of Lord Shiva is what these people are doing. And they are really dedicated. One or two, but we can think. But these sort of great judges make this democracy function. And anyway, this is I'm making for students as a case study type of approach, which I'm going to show. Now we'll go to the next one. The sociological school of jurisprudence, the utilitarian part of law, is the emphasis wedded to the constitutional values. If we see this Justice Abhay, the way in which the law is delivered, judgments are delivered, the outcome is kept in view fearlessly. But then it's like a dynamic situation because it not only serves the current purposes and the emerging situations, long-term, future generations. We will take one of the many things we'll talk on that, but just this is introductory part. As I told you, this is we want it to be useful mainly to the students of law, then the young advocates. Yes. Jurisprudence derived from Latin, juris prudentia, meaning knowledge of law. It is a philosophy or science of law, exploring its nature, purpose, and functions within the society. Now you see, dear friends, we know that Parliament, the job of Parliament is to make laws. They produce laws, taking into consideration the needs of the society, emerging needs of the society, which is represented by Parliament, lawmakers across the nation. Then we have executive to implement laws. Subordinate legislation also comes, they will do that. Then comes the judicial. Judiciary, the duty is to interpret the laws. So you confine only to interpret law. Then there is a word of judicial activism, doctrine of separation of powers came. Then this school jurisprudence, Justice Holmes, very clearly said that who makes the law? He said, I don't agree that it is the Parliament which makes law. The law is made only by the judicial officer through the process of interpretation. The laws made by the Parliament are basically static in nature. But it is the judge who do the process of things will do. Again, he mentioned in one of the judgments, United States, that justice without power is inefficient, and power without justice is tyrannous. And therefore, the judiciary is the ultimate for a democracy to serve in our nation, the well-being of our people, of this country. Ours is a progressive economy, divergent economy, a nation of like a continent, but we are stable, unlike the dictatorial Pakistan. Even here also dictatorship is growing, but not as much. People's democratic rights are exercised only through the medium of strong judiciary. And the strong judiciary is basically because of the great judges like Justice Abhay or H.R. Khanna, is the uncle of our current Chief Justice of India, and Justice Iyer, Krishna Iyer, and many others. I don't want to, everyone are great by themselves, but these people can be coming under the class of extraordinary personalities. Now, how did we analyze and how we comes under this is, if you see the judgments, justice delivery is not just a process of interpretation of laws made by the parliaments as they're static. This you can get a feel of his judgments. Justice delivery should be dynamic and organic, but set the law in motion through the process of interpretation. And justice delivery should always have long-lasting and positive impact on the subjects and society, both in short and long terms. If you'll see the Lordship's judgments, that's a separate aspect, but summary of how the judgments can be read. We had a situation where Enforcement Directorate used to go and arrest people, and for years he put them in jail, and the conviction rate is abysmally low. But then that has survived for long, and it's been used as a political instrument to attack the opponents. And a lot of criticism that fundamental rights, bail is a rule and jail is exception, has become jail is exception and bail is rule. But when the case came before these lordships, he focused and reiterated that concept of bail is rule and jail is exception. But it little late. any judgments, if you take the way lordships decide is, from whatever we understand, one is comes well prepared, adapts to technology, and does a lot of work, but inherently is very knowledgeable in the sense that that intelligence is how even if you don't know the law, he knows how the law should be. And if this is the interpretation in a given situation, this will be the outcome. Whether that outcome will be relevant and necessary. That is how the great judges have checked, many of them. They understand that particular case and the particular law that is applicable, and then particular outcome, particular relief, which may not be common for everything. How it should be taken to the logical conclusion. In one case I was watching, that is one school teacher in Uttar Pradesh asked the Hindu boys to beat up a Muslim boy, poor boy. And that case came before the lordships. Then the whole nation under trials, languishing in the jail without being finding justice. He took up that. That is the Article 21. Fearlessly, he believed that it is most precious of the few precious fundamental rights, and accordingly delivered the judgments, unmindful of the outcomes. Fearless, but at the same time, make sure it's a balance between the executive and the adjudication. So I come to the conclusion, he mixed rightly, a right balance of mix of administration, executive powers with judicial powers, and exercised the powers of Supreme Court, Honorable Supreme Court, and long-lasting impact. But of course, here in a situation like this, you must understand how we are in. I will give a simple example. Lord Krishna will come, and on the day of the death of Bhishma, he appears in the dead of the night, and full of burning body smell and all that, complete loss of life. Then Bhishma will ask Lord Krishna, do you think, I know this Duryodhana and all are bad, but you are with the dharma. Did you perform the dharmic thing righteous way? Why did you kill Abhimanyu? All those points, Karna skill like this, so we will be talking. That time, Krishna will tell Lord Krishna that you ought to understand in what context we are in. In Rama was there, in that Yuga, Treta Yuga, where even Ravan was following rule of law for fighting and all, and everything was going. Ravan is not ordinary person. He was a highly qualified Brahman, Vedic, he read Vedas. But then when it comes to Dwapara Yuga, the rule of law has changed. Therefore, we have to apply it in this context. And now Kali Yuga will be worse than everything. So we are in the same 1950, 25, 75 years of independence. Situations are changing. Therefore, adjudication also will be changing without compromising on the values of the Constitution. That's what the lordships have come out with, is my opinion. And he has exemplified these qualities which are referred to in Vedas and all. The judge should have extraordinary intelligence. Intelligence here doesn't mean the book intelligence, the live practical intelligence, because the law that is going to be laid down is going to have far-reaching impact on the society, on the subjects. and desire to acquire knowledge. Knowledge is a dynamic process, and therefore today many of the people are not at all using the technology, artificial intelligence. But I used to hear the lordships used to using the best of the software and to use it, the skills, improve, enhance, all that. Now, fearless, strict, balanced, kind, and good listeners. In one senior counsel, the senior counsel advocate, I was there that day. A day he misrepresented the court, and believing the senior counsel, he passed order. Later, the ASD told them this is wrong. He took it very seriously. He said the senior counsel is next to the judge. We trust you, and if we can't trust you, what exactly is the possibility? He was strict with advocates on record, taking things easily. And he's strict only. There is not that kind, and it's according to the rule of law. Exactly, it will go through. And as we said that, through the process of organic interpretation, there is a solution-driven judgments. Ultimately, it serves the purpose. And that is the qualities. Maybe every judge who is that capable will do it. And those judges can consider, understand these things. With live example, I'm going to talk. And this is a highly theoretical one for our students. I'm taking in the second these things. And now, how a judgment is taking place. Many things we have taken as videos, we'll be showing you. And this is a case. The Honorable Judge at the admission stage came, and he said that this is an NCLAT judgment. He asked that there's a 46 pages order is there, and I'm not able to read anything in that exact law, point of law, nothing is there. He said, and by the time we could see, the other side, the judge, lawyer, senior counsel was saying that this clauses act is used and all. Then he asked that, you see, whether there is that means that jurisprudence of law, first clear cut, that is inbuilt in him. That's called as, all the top performers have this intelligence, wherein he said, how should the law be? When should you apply this other law? And when the other law is specific provision in the code is there, how can you apply this law? Therefore, it is wrong application of law. Once he has decided, that's all, he is not favoring an inch also. And then it is the same case came up for final hearing. And then he was about to say that the other advocate, senior advocate, made a false statement. Of course, he was junior, that other lawyer told him. He said the other person has done excellent job, then they got a solution. Then immediately asked me that since that part is done, is it worth? Then he gave a solution to me also, which I thought that time is not the solution. But later I realized that is the real solution. So let's see. This is called as the Sociological School of Law. And you can see, I've taken several of these judgments. You can see here first how we adjudicated upon. So here,
it could also be under the NCLT inherent powers, the rules which are
the statutory power is saying,
yeah,
the statutory power which says just read 24. This is the only power to remove. And you can't say that you will fall back on some inherent power. Now just see. Just see 34 for the
yes.
The adjudicating authority shall, by order, replace the resolution professional if the board recommends the replacement by resolution of. So what is that resolution? No, do you want to know whether there was any recommendation by you for reasons according to for his removal.
May I just point out one? But in this, there is clear separation by. As far as IDBI,
We just want to know which is the power exercised by the tribunal. NCLT, which is the power exercise. If that power is correctly exercised, obviously he is out.
yeah, there
With the law judgment, we are really unable to understand which is the power exercise.
there I think one section 16 of the general clause there. If the NCLT appoints,
Just 1 second.
Yes.
Under the statute,
yes,
which provides for removal,
yes,
then law is very well settled. And if law requires you to do something in a particular manner, you must do it in that manner. That's what we want to know from her. Whether there was a report, a recommendation by the board. Right? No, don't find just.
So here if you see, dear friends, the adjudication, he has just come and I believe should not have been 46 pages, didn't read. But then the inherent strength of that is clear. And when the senior counsel of the other side was saying, then clearly he said, you want to remove a person, you are challenging the removal, appointment of a person. So the person would have been appointed with some provision. You explain the infirmity in that. That's all. This case went 1.5 years before NCLT, maybe other side would have spent 2-3 crores of rupees. That was settled within 2 seconds, 2 minutes. And then he is very clear. If you are able to show me that this is the law, this is the procedure, there is a unfairness is there, and infirmity is there, you will remove him. Why do you use general clauses? The entire case revolves around that point, which the NCLT are not followed. Then this matter went on for some time. Is quickly the Lordships understands. But then it doesn't go by that. Exactly true by law. And the environment analysis, impact analysis, everything was being done. And when the matter, the Lordship believed that this matter needs a detailed hearing because there are a lot of issues are involved in this particular case. And then the matter was coming. When the matter started hearing started, that the senior counsel appearing, you see.
A new liquidator was appointed by the NCLT by the same one. Now, subsequently, of course, they have appointed somebody else.
Now, that person also has been changed.
That person remains.
Okay.
Now, because of the course of proceedings, I am not going into the allegations. Because of that, the fresh expression of interest have to be published again.
Correct.
And that process is now reached a stage where the resolution plan is in place. It is being considered. So therefore, much water has flowed.
The process for appointing liquidator in this place is at final stage.
No. He has been appointed. There is same point. It's not the challenge. And that the new liquidator has taken substantial steps for almost 2 years.
So this is a situation where they were about to adjudicate the matter. And the senior counsel, one Mr. J.B. Gupta, is very good judge, good lawyer, nice person. But he was told by the advocate on record like this. So I also thought when they got the problem solved, why should we? He also, Lordship said that now that this is there, what will be the things? Would you like to go there or not? He asked me. I said, no. Then if you're not interested to go there, where is the case survives? And then Lordships ensured that the adverse findings by NCLT and NCLAT will be removed. At that point, I thought injustice being done to me. But then when I heard the senior counsel, I believed it is correct. But later only I found that NCLT Chennai bench passed an order saying that the IDBI bank wanted to remove the liquidator for doing no work. and they don't have any resolution plan, and the company where they could have got 1,000 crores has gone to again in trouble. Nothing has happened in the 3 long years of that. But then what the lordships can do, what we can do, he would have taken it very seriously. Recently, when Malhotra was stripped of his senior counsel post. So here what you do is, if you see this sociological jurisprudence, try to find a solution to a given situation. And you have to be so alert, Supreme Court is the highest court. And they set the law in motion. That will be the law for the entire country. And so the qualities of the judge. Now, I've taken so many judgments, recent judgments also, senior advocates, Indra Jaising madam was speaking almost quite long time. These are all there. One by one, we'll be sending it to all colleges, and so that you all can look into this. This is me, Venkat Shivakumar. And the lordships, if you see, is adapting the latest technology. And if you see, let's just so much is there, you can see.
There is a popular misconception that the judiciary started using technology only after national lockdown was declared on 25th of March 2020. I can only say that the lockdown worked as a trigger, and the courts were forced to use more and more technology and to innovate. I must say here that using video conference as a medium for conducting the court is a very, very small and negligible part of use of technology.
And the lordship explained how a judge comes, how he prepares. And he actually said that many times we don't have time to prepare. But then based on the way in which you present the case, he explained what is required for a judge to at the stage of admission, and how an advocate on record, an young lawyer, has to prepare before he presents his case, etc. So we'll continue this other videos. Each video we'll analyze in our next these things. Thank you, friends.